Good afternoon, everybody. We're going to call to order. We're not going to do a roll call, and we'll just mark everyone's attendance. Good afternoon. I'm Wisconsin State Senator Mary Felskowski, and I will be chairing this meeting today. I'm going to ask for a motion to waive the quorum requirement, and then a second, and then a voice vote. Could I have a motion, please?
So moved.
Thank you. Second? Second. And then a voice vote for, an aye? Everyone say aye?
Aye.
Opposed? Before we get started with our agenda, I'd like to note that we're continuing with the new testimony process that we introduced at our last meeting in November. Anyone in the audience who is not scheduled to speak on an issue can fill out a testimony slip stating who they are representing and what their position is on an issue. The testimony slips can be found on the speaker table. After completing the slip, you can submit the slip to me or whoever is staffing the committee next to me, and then it will be incorporated into the minutes after the meeting. You can feel free to submit a slip on any issue. It doesn't necessarily have to be a matter law or resolution. So we are going to switch up the agenda, as I said. So we're going to start out today. We're going to start out on discussing on NAIC's model framework for regulation of insurer investments, including the proposal relating to SVO's ratings and discretion process. We had a good update on this topic yesterday during the NCOIL NAIC dialogue, and now we'll have a chance to discuss it in a little more detail. For those who weren't at the dialogue yesterday, this topic has generated a significant amount of discussion throughout the past several months, and it deals with the NAIC's proposed framework for regulation of insurer investments, which you can view in your binders on page 104. Within this framework, there's a specific 15-step process set forth that enables the SVO to review all filing exempt securities and to determine whether the rating is unreasonable for regulatory purposes. That 15-step process is on page 111 in your binders. All materials are on the website and app as well. Concerns have been raised by many regarding the framework, mainly focusing on the SVO's authority to overrule the decisions made by rating agencies. We do applaud the NAIC for making progress on the proposal and its willingness to engage in discussions and hear concerns. With us here today is the Insurance Commissioner from the great state of Wisconsin and Chair of the NAIC's Financial Condition Committee, Nathan Hudak. Commissioner, thank you for being here, and please go ahead.
Thank you, Madam Chair, members of the committee. Appreciate the opportunity to be here, and thank you for the flexibility of moving the schedule around. I love Nashville. It's a great city, but I do want to catch my flight to get home today, so thank you. So we have a lot of ground to cover, so I'm going to dive right in. I'm going to provide a little bit of background information before I kind of dive into a little more of the substance of the framework. Some of this might be familiar for those of you who were here for Director or Superintendent Beth Dwyer's presentation last fall when she talked about the investment framework. But just as a reminder, so as state insurance regulators, one of the key things we're charged with is ensuring the financial and solvency of insurers. And as part of that, being able to properly analyze investments is really a key function of financial solvency oversight. And what we've really seen, and I mentioned this yesterday during the dialogue, is we've seen a material and observable shift in insurer investment strategies over the last decade or so, really since the great financial crisis. And we've seen a move towards more private assets, more structured assets, more complex assets, and from our standpoint as regulators, just less transparency overall in terms of being able to analyze the risk associated with these newer investments. And so this project of the framework is really, we're really trying to determine the most effective use of our regulatory resources in this new modern environment of these more complex and more challenging investments so that we feel comfortable that we understand the risks associated with them. And that's really what this project is focused on, is how do we enhance the ability of us as regulators to do that financial solvency work and ultimately to protect policyholders and consumers. So for kind of a background process standpoint, so the framework document was initially exposed at the NAIC Summer National Meeting last year. During that exposure period, we received comment letters from 17 different organizations, as well as oral comments that were presented by many of those same groups at the fall national meeting in December. We then put together a small drafting group, which was comprised of regulators who really have subject matter expertise in this area. And they spent really the winter months, I would say, kind of December, January, early February, drafting 3 documents based on the comments we had received and just other information that had come to light since we initially exposed the framework. Those 3 documents were first a proposed work plan laying out, I believe, 7 action items in terms of kind of next steps of how we move the framework project forward. Second was an update to the framework document itself, fairly minor revisions at this point, but a few changes that we thought were helpful. And a third, more substantive memo, kind of generally to interested parties with responses to the comments that we had received during that initial comment period. We then exposed those 3 documents in February for a comment period that ended just this past week, April 8th. And we also, at our spring national meeting last month, provided an opportunity for interested parties to provide verbal comments. I think we had 5 or 6 different groups that did that. And so where we are now is essentially the drafting group members and the E-Committee, the Financial Condition E-Committee members, are now going to go through those most recent comment letters that we had received, spend the rest of this month and next month with the idea then we will revise these documents that had been exposed earlier this year, determine if any additional documents, whatever additional information might be needed based on the comments, and expose those for an additional comment period, likely in, probably in June, I would say, that will occur. So there will continue to be a lot of opportunity for all stakeholders and interested parties to have transparency into how we're doing this process, the changes we're making, providing feedback, providing comments. That's something we've committed to and something that as the process continues, we will definitely adhere to. So I want to touch on, included in the work plan document that was exposed earlier this year, are really kind of 6 core principles of the investment framework. The first being that the framework is really, we're putting it out there to set a long-term strategic direction for really where investment regulation is going to go in the future, given these changes that I talked about, structured assets, private assets, more complex assets. And also to help ensure that both the current and future initiatives that are happening under the E-Committee are coordinated and really supportive of this longer-term direction. Second, we really want to ensure that insurance regulators have the appropriate tools, and that's something that you'll hear as I kind of talk through some components of the framework. It's really about enhancing our resources, our tools, and the policies that we have in place to ensure that we can have the appropriate oversight of these new investments. The third principle, really restating and just reiterating the fact that the work that had been going on related to the framework will continue and there will not be a delay. We want to ensure that that work and those work streams are directionally consistent with where we're going with the framework, and we will continue to look at that work and make sure that is the case, but there is no intention to pause or to stop that work. And fourth, and this is something that we've heard some concerns and criticisms about, but we really want to reiterate that this work is being driven by regulators at the commissioner level, at the senior staff level. Yes, we might be hiring consultants for some of the work, which we'll be transparent about. Yes, we rely on the SBO staff, NAIC staff, but it is really the regulators and commissioners, E-Committee in particular, that is really driving this work and who are benefiting at the end of the day from all of these enhancements and resources that we're developing. It's really about the fact, when you have 56 different jurisdictions that oversee the regulation of insurance, it's not practical for each of those jurisdictions to build out the full capabilities on their own from a cost standpoint. to be able to do in-depth analysis of investments. So what we're trying to do is do this in a coordinated way where we have a centralized location, the SVO, or whatever the SVO will look like in the future, that benefits all of us as regulators in those 56 jurisdictions. Fifth principle is, again, we're committed to being fully transparent and continuing to have multiple checkpoints, exposure periods, comment periods throughout this process. And last, we really want to reiterate that while we're doing this work to bolster our resources, to improve oversight of the ratings from the CRPs, at the end of the day, it's the ultimate responsibility of the insurers to have prudent oversight of their investments. And the work that we're doing doesn't mean that that oversight should be outsourced to regulators. It just means we have to do this work from a regulatory standpoint so that we feel comfortable with the tools, resources, and knowledge that we have. So now I will, I think I'm doing okay on time. I'm going to dive in to kind of peel back the framework a little bit and talk about some of the specific proposals that are included in the framework. And I'm trying to move through this quickly to provide time for questions at the end, because I'm sure folks will have some questions. So the first proposal relates to the issue that we talked about, this idea that right now as consumers of ratings from credit rating providers, we, the NAIC and insurance regulators, really have to blindly rely on those ratings. And a big part of what we're trying to achieve here is to move from blind reliance to informed reliance. We really want to create parameters, both quantitative and qualitative parameters, that the CRPs have to meet so that we feel comfortable with the ratings that are being provided to us, again, as consumers of those ratings, that there is uniformity, consistency, and a level of quality in the ratings that are being performed. And that's really, a big part of what we're working through here when we talk about this idea of having more oversight of the ratings and how those track to our NAIC designations. Second, kind of related to that, we want to retain the ability of the SVO to perform assessments of individual securities and to utilize the discretion, which we've talked about, that is being developed so that when there is identified some concern or anomaly, that the SVO has the proper tools to do that credit assessment and utilize the discretion process that has been laid out through those 15 steps. Third proposal, currently the SVO is really set up to do credit assessments of individual securities. And as we're looking to enhance the tools that we as regulators need to understand this more complex investment environment, we really need to look at enhancing the risk analysis capabilities of the SVO itself to move beyond individual credit assessment to look at company-specific, company-wide portfolio assessment, as well as looking at kind of risk assessments across the industry. This is really in line with the risk-focused surveillance move that the regulatory community has been making over the last few years and ties in with our broader macroprudential regulatory oversight efforts and responsibilities. So, think about it as rather than waiting for some event to occur that leads to a problem, we're trying to develop the tools and build out the resources so that we can identify problems on the horizon and try to take steps to address those before they become a bigger problem. Fourth, we want to continue to build out the modeling capabilities. Again, these are all pieces of a broader whole, right? So as we're looking at potentially doing, if there's a challenge to a particular rating based on the discretionary process, we want to have the modeling capabilities to be able to do the proper assessment and analysis within the SVO. So building out those additional resources and the governance associated with that is going to be a critical piece of that. Fifth, we also want to add some policy advisory functions at the SVO. So instead of just doing, again, credit assessments of individual securities. We want to add the ability to have some advisory services that could benefit all of us as regulators to really understand, what are some of the emerging issues and potential problems that we need to be aware of as we continue to see the investment landscape shift in the coming years. This is something that's similar to how the American Academy of Actuaries supports the NAIC and state regulators right now in terms of our RBC and reserving initiatives. This would be similar, but more focused on the investment side. And then 6, so there's 2 more. So 6, so currently we have 2 regulator-only working groups that are really designed to provide a forum for discussion about confidential company, really troubled company specific information. And those are referred to as FOG and VOG, or the Financial Analysis Working Group and the Valuation Analysis Working Group. Proposal 6 would have us develop a similar regulator-only working group that would provide a confidential forum where we could discuss investment-related risks and concerns in a way where we could bring in a broader regulatory group to really understand across states, across different subject matter experts, what are issues that we as the broader regulatory community need to be aware of as it relates to the shifting investment landscape and challenges that might be associated with that. And lastly, the 7th proposal relates to kind of some restructuring of the SVO and renaming the SVO and the Valuation of Securities Task Force, as it says, to better reflect the responsibilities that we are, that these groups would have based on all the changes that I just talked about, as well as making sure the SVO is empowered to utilize these new tools and resources that we intend to develop to support not just regulators across the country, but the various working groups and other committees under the NAIC structure overall. And then also look at potentially reducing the size of the VOS task force membership to encourage more active participation and membership who have more of a subject matter expertise and really are willing and able to dive into these issues in a more substantive way. So in conclusion, just these 4 points I want to touch on. Again, these are really tools and resources that we're looking to develop to make sure that we as regulators can properly analyze the risks associated with these new investments to ensure that companies remain solvent. The ultimate goal is equal capital for equal risk. So capital requirements, capital charges should be the same for similar types of investments, and that's not always the case right now, and we're hoping with better tools, with better resources, that we can do a better job of accomplishing this goal of equal capital for equal risk. As related to that, as the financial regulators, the more we can capture the accurate risk and assess the appropriate capital charge, the more we can reduce the need and desire of companies to pursue regulatory arbitrage. So if we can get all these other parts right, we should create an environment where we don't see companies trying to take advantage of loopholes and opportunities for regulatory arbitrage. And then just the last point to make is the SVO and regulators overall are completely committed to continuing to rely on credit rating providers and the ratings that they provide for NAIC designations. There is no goal to have the SVO compete with the CRPs. There's no goal to put any of the CRPs out of business. The goal is, again, to ensure that right now we have to blindly rely on the ratings that come from CRPs that feed into our designation process, which have an impact on capital requirements and accounting standards and a number of other functions for us as regulators. We want to shift that to being a system where we have informed reliance on those ratings. And ultimately, that's the change that we're looking to do with regard to CRPs. The SVO there's no way that they could take over or in any way compete with the work that the private CRPs do, and we don't want that to happen. From the E-committee standpoint, we're not pushing that. There are no task forces or working groups that are pushing that. So that's something we always like to reinforce, because I know there's some misinformation out there about that, but there is no attempt to compete with or displace any of the CRPs. So I will stop there and happy to answer any questions.
Thank you, Commissioner Hudak. I'll now open up the conversation to the legislators. Does anyone have any questions or comments? Representative Lehman.
Thank you. Thank you, Commissioner, for being here. And we've been talking about SVOs now for the last several meetings we've had, and even some of our meetings with NAIC. A couple of things that still maybe are a bit of a concern that I'm hearing. In the proposal of the 15 steps, there's some language in here about, we'll review, but if we're off, is it like 3 points, we'll discard that rating and use our rating, or we'll discard the rating. And then one of your bullet points there was to use the term empower the SVO. And whenever I see the word empower, I always wonder where that's going to go, because it does concern me that when you said we don't want to compete, and it's a resource. And so I think my only concern is I don't want to see that creep over into, that becomes our rating service, and we don't really need them anymore. So that'd be my only concern, and some of the things that I'm reading here, I know President Oliverson's had some of the same concerns in the past. So as we keep moving forward on this, I think it needs to be something that we continue to have a dialogue about.
Oh, that's great. I appreciate that feedback. And I know the discretion and oversight process that's being developed is still in the process of being developed. I talked with the Valuation of Securities Task Force Chair on Friday or Thursday, and the plan is to take the most recent round of comment letters and take the rest of this month and into May and continue to refine and update the 15-step process and just the overall kind of process that's being laid out with regard to discretion. So I don't know the details enough to speak to those issues, but just know that there is additional analysis being done and initial kind of refining being done in terms of the feedback that we've been getting on some of these issues.
Thank you.
Senator Hackett.
Yeah, and part of my question was what Matt said, so I'll go to my second part. We went through 08 and 09, and part of we had a major crisis, not as much a crisis in our area, but in crisis in the financial markets. And the major mistake that was made by great rating services like Moody's, as you know, as mortgage-backed bonds. The only thing that I worry about is, did we learn from the past? I mean, it wasn't that, people did a mistake. That's the way those bonds were rated. They were rated tremendously more conservative than they should have been under that scenario. And so, I mean, I understand what you're trying to do, and I commend you for what you're trying to do, but the same token is it still worries me that we might hit a crisis because, we not only look at the rating services, but we also look at the consultants. And you know what I'm saying under the scenario, but
yeah,
any comments?
Yeah, I do. I know what you're saying. And, I think, the tools and resources that we're talking about will hopefully identify those risks and potential problems. But I think, to your point, it's then incumbent on us as regulators to take action when we see problems. And, I wasn't in a role, at that time to have done anything, but I think we need to continue to proactively identify where there are risks in the system, where there are potential problems, try to identify those, and when necessary, take action to mitigate and prevent, those risks from becoming bigger problems. So I don't have an answer because all I can say is hopefully we're doing the right thing, and hopefully when that time comes, these tools and resources that we've developed will serve us well, and the right action will be taken to prevent those kinds of things from happening.
Any other questions? Seeing none, thank you, Commissioner, and safe travels back to Madison.
Thank you very much.
Up next, we'll go with the introduction and discussion of the NCOIL Transparency and Third-Party Litigation Financing Model Act. And we've got our panel moving up, and we'll turn it over to the sponsor of the model, Indiana Representative Matt Lehman.
All right, thank you, Madam Chair. I'm really privileged to be able to bring this model today, and for the sake of some history. And if you have your book, you can look, it's on page 235 in your binder. For those of you that may have been around here a while, this issue first hit NCOIL's radar screen in 2011 at our annual meeting in Santa Fe. And then over the next probably 3 years, myself, Senator Breslin, and Senator Charles Curtis from here in Tennessee worked on some language and came to a final vote at the annual meeting in 2014, and it failed 15-14. And, you know, so for those of you that ever have had a model get defeated at NCOIL, which is very rare, I've had one. Okay, so, and that did not end my career at NCOIL. But so there's been a lot of discussion as to what's changed since then. Well, that's been a decade. And I'll tell you what's changed. I think we've seen a growing in the consumer space. We've seen some growing changes that I know in Indiana we've addressed, and some other states have as well. The other thing is we've seen the influx now in the commercial space. And I think that's what's really caught our attention as public policy makers, because we were beginning to see more and more of these lawsuits turning into nuclear verdicts, and eventually we, the policyholders, bear the brunt of that. And what was troubling in a way, I would say, is we began to see or did not see who was behind the funding, who's putting the money into this process. There was no transparency in that. We began to see cases where they were directing the case. They were directing the suit. The funder was. We began to see that some of these cases might be around not so much an investment to get a return on my money, but simply I'm data mining. I'm going to sue Google because I want their mapping technology. And as long as I can be a seat at that table, maybe I'll get that data. These were coming from foreign investors. They were coming from foreign countries. And that really began, you saw articles after articles began to hit in courtrooms. The one quote I really liked is that our courtrooms have become a trading floor. And, you know, I'm a student of history. I love history. I've read the Federalist Papers multiple times, and never did I find anywhere there where our founders wrote that the judicial branch should be set up as an investment tool. And so I think we have to be very careful when we get into this world of the judicial branch and litigation. Now, that being the case, there's been some that have said, you know, why don't we just get rid of this? I think there's still a need for the product in certain cases, because we do want to level the playing field and make sure people do have access to the courts. And in some cases, we can't just say, because I have more money than you, I win. So I think that what I've tried to bring here now is a model that addresses both of the issues that I think are before us as policymakers, and that is the issue of consumer lending as well as commercial lending. From a consumer's perspective, I think these become very complicated and very troublesome in that we've seen some cases on the consumer side where the litigation went forward. They took the loan and walked away with less money than anybody else involved. And so, again, I think that needs to be addressed. So I'm going to do this. I'll briefly walk through a little bit of the model and then turn it back over to you, Madam Chair, and then a little bit of what I hope is our path moving forward. So in the consumer space, we do put in there language around just registration, making sure that we're regulating the industry that is doing this within your states. We put language around the limit on charges. I think this one has it at 36%. And then on the commercial side, we prohibit the funding from the foreign entities of concern. I'll delve into that a little bit. But then what would apply to everybody is that issue around driving the litigation. You'll have no say in what the attorney and the clients decide they want to do on a case. If they want to settle, they want to continue, that's up to them and not up to you, the funder. The other thing is you will not have access to proprietary data. If I sue somebody over something, a trademark, a lot of that information is disclosed. It's held in confidence by the court, but if I'm the funder and sitting at that table, I've now got access to it. That needs to stop. And so that's in both sides of this on the aisle side. On the commercial side, what I attempted to do in Indiana, and I still lean that way, but I understand more where we ended up and where this is at, and that is we really wanted to focus on prohibiting those who are investing in our legal system who are not our friends. What passed out of the Indiana House was any foreign entity, and what passed out of the Senate as the compromise was those that are of concern, which the federal government has a list of those. Those are China and Venezuela and Cuba and countries like that. So this model does address the countries of concern. And I'm going to now go maybe to my philosophy at INCOL has always been, always will be, we will never craft the perfect model. I think someone earlier today said this model is perfect. There's no, not this model, the model they were talking about earlier. There's no perfect model because I think INCOL's role with, I think we have 31 different states represented here, is you're always going to go back to your state and find it fits different in your state than it does in my state. INCOL's role really should be, my philosophy has been, is we build the foundation, we put the walls around it, maybe we put a roof on it, we seal it up so it's a nice and secure, neat thing to look at and get as a good template, go back to your state and fill in the blanks. We put in here that we open all this up to discovery. Now that's going to be a problem in some states because some states, insurance policies and their limits are discoverable. So then this should be discoverable. The contents of this should be discoverable. Other states don't allow that. So maybe we have in here that the existence of is mandated, but not the contents of. So I think when you get back to your state, there's always going to be a different path you may take. I'll kind of wrap up with this, and that is I think that we're on the forefront of this issue in a way. I know as we were going through our session, Florida had, I think, a bill, Georgia had a bill. At the end of the day, the last two standing were us in West Virginia. So I have talked to Delegate Westfeld and asked him if he would be willing to maybe a co-sponsor on this. There is some language I know that came out of West Virginia that we would like to look at, and my path here would be to listen today. I want to hear why this is the best bill ever, and I want to hear why it's the worst bill ever. And so you tell me what we need to change in this bill, and we'll take copious notes. I'd like to have an interim call between now and Costa Mesa. If we can get it to the right place, then we'll move the model. If not, we'll have another vigorous debate. We'll have another interim, and then hopefully in November we pass this out. As states begin to draft their language for upcoming session, they can have a good model to work with. And if I may, Madam Chairman, is to defer to Delegate Westfeld and see if there's anything he would like to add to that before we open this up to the panel.
Absolutely.
Thank you, Madam Chair. Yeah, we did at this station, Senate Bill 850, which the short title of it was Consumer Credit and Protection Act. It went a little bit farther, I think, than what Indiana's, this model bill we have here and stuff. So if no objection, I would like to be co-sponsor of this bill. I think it's not a perfect bill, but we think it's a great bill. We had a lot of support from the chamber, and we passed this not without a lot of objection, but we got it passed and the governor signed it, so it is the law in West Virginia. So for those reasons, I'd like to be co-sponsor of the bill also.
Without objection. Okay, thank you, representatives. We have several speakers here today, so please be sure to limit your remarks to no more than 5 minutes so that we have some time for question and answer. So let's get started by first hearing from Harrison Hosker of the American Legal Finance Association. We'll hold questions until everyone is finished. Harrison, please go ahead.
Chair and committee members, I'd like to thank you for the opportunity to appear this afternoon. My name is Harrison Hosker, and I'm appearing on behalf of the American Legal Finance Association, or ALFA, which is the oldest consumer litigation finance trade association consisting of the nation's largest and leading companies in this market. Our organization has long been an active attendee and participant at NCOIL. Most recently, we testified last November at the Columbus meeting discussing litigation finance. Alpha is not new to NCOIL's discussion of this subject. 10 years ago, Alpha proactively sought NCOIL's adoption of past NCOIL President Senator Neil Breslin's model legislation to address oversight and regulation of this practice. Regrettably, the model was not adopted at that time. However, I note that NCOIL members returned home to their states and adopted legislation modeled on the proposed language. We commend NCOIL and Representative Matt Lehman for taking up this issue again with his introduction of the Transparency in Third-Party Litigation Financing Model Act. I want to take a moment to discuss the unique distinctions between consumer and commercial litigation funding, as both are captured under the proposed Model Act. These two transactions are distinctly different fundings that are often conflated, creating significant confusion in the development of public policy. Commercial litigation funding is a product that is used to fund the prosecution of litigation by funding the actual costs, including attorney fees, the cost of discovery, research, deposition, witness fees, marketing, and other expenses associated with the initiation and pursuit of a legal claim. Commercial litigation funders often include private equity, large institutional investors, and investment funds that become involved in the litigation before the legal action is actually filed and initiated. Commercial fundings in many cases involve millions upon millions of dollars, in effect investing into the pursuit of the litigation and its results. These sophisticated institutional investors and underwriters have numerous analysts and legal professionals to determine and underwrite the risk and value of the investment in large multi-million-dollar complex disputes involving, amongst other things, intellectual property, product liability, bankruptcy, and antitrust. This type of litigation often involves multiple jurisdictions, resulting in hundreds of millions of dollars in settlements or judgments. Commercial litigation funding is distinctly different from the transactions that the members of Alpha provide. Alpha members provide consumer litigation funding, a transaction where a small amount of money, typically several $1,000s, is provided to personal injury plaintiffs to assist them with their personal life needs. Consumer litigation funding is only provided after the plaintiff has filed their case. Therefore, such funding has no role in the litigation being initiated. While pursuing a personal injury claim, these funds are provided for life needs such as rent, car payments, mortgages, groceries, and other personal financial needs. Consumer litigation funders do not provide funds to prosecute litigation. It is critical for the committee to know that the funds provided by Alpha members are contractually prohibited from being used for any costs, fees, or expenses related to the prosecution of litigation. All Alpha members must adhere to this contractual standard and all other standards established in our best practices. Alpha's best practices include prohibiting any funds from being used for the cost of litigation, prohibiting the funding company from being involved in any decisions relating to the litigation, prohibiting funding companies from paying any referrals or kickbacks, and prohibiting funding companies from using false or misleading advertising. The Model Act before you today contains many of the policies, such as registration and reporting requirements, banning referrals and kickbacks, and mandating clear and easy-to-read contracts that Alpha has worked tirelessly to adopt in law across the country. We have several technical amendments that we'd like to see included before the Model Act is approved, but it is our intent to be fully supportive of this model. In closing, I'm grateful for the opportunity to appear before this committee, and I stand ready to answer any questions you might have.
Thank you. Next, we have Eric Schuller.
Thank you, Madam Chair. My name is Eric Schuler. I'm the president for the Alliance for Responsible Consumer Legal Funding, a trade association that does represent the companies that do offer this product. Currently, we have 46 members in our association. I won't repeat a lot of the stuff that Harrison stated because I agree with a lot of his statements. But there are a couple things I just wanted to maybe reiterate on. One is we respectfully request that this piece of legislation be divided into two pieces of legislation. One dealing with the consumer side and one dealing with the commercial side. I can tell you I've been dealing with this issue for about 17 years now across the country, and I can tell you that the two issues get conflated all the time. When you have someone talking about funding of litigation, they think it's a consumer getting $400,000 to bring a class action lawsuit. Our average funding to a consumer is about $3,000 to $5,000. and that's used specifically for household needs. As Harrison stated, roof over their head and food on the table. As was stated by one of the largest funds that offer this, Burford, in the 60 Minutes piece, I'm sure a lot of you have seen, their minimums start about $3 million. So just a couple of zeros difference between the two. One of the things that we want to make sure about, too, in this is that by having two pieces of legislation, you're not going to conflate it. ARC, like Alpha, we welcome regulation of the industry. Unfortunately, it has been stated a lot of times is sometimes the commercial folks don't want regulation on the industry. That's their issue. That's not ours. And my concern is by putting this all into one piece of legislation is you're going to have people within the space that are going to be divided on it. It's basically the equating of this is that we're both fruit, but we're an apple and they're an orange. One of the other things we'd like to address is the issue on the rates that are currently in the piece of legislation. Our recommendation and suggestion would be is to take a specific rate out of the bill and let each individual state determine that. We have some states like Missouri last year that didn't have rate restrictions, but we have other states like we worked with Representative Lehman in putting in rate restrictions in Indiana, and just let that each individual state address that issue. One of the other issues that we'd like to address respectfully with this is on the disclosure of the product. You know, what was initiated years ago, the last few years, was automatic disclosure of the product. We don't agree with that. What we've come to agree to is kind of what we worked with Representative Lehman on in Indiana last year, whereas there's an acknowledgement that the consumer has won these transactions. But if you want any more information on it, it goes through the discovery process. But the normal discovery process of that state, it should be not more discoverable or less discoverable than any other financial product that the consumer has. So if you need access to their bank accounts or whatever it is, this should not be treated any differently. And then finally, where it is inadmissible against the consumer, it cannot be used against them in any way. And then finally, what we'd like to do is work with the members of this committee and anybody else that has interest in this in making sure that there is a piece of legislation out there. As I stated before, we like to have this industry regulated, but also we want to make sure that's good for the consumer, good for the legal system, and also good for our companies. Be happy to answer any questions you have. Thank you.
Next up, Daniel Hinkle.
Thank you, Madam Chair, and hey, everybody. My name is Daniel Hinkle. I'm the Senior Counsel for Policy and State Affairs at the American Association for Justice. That's the trial lawyer organization. AAJ is the largest plaintiff's trial bar in the country, but I'm here today to be helpful to the committee. Each individual state has their own state trial lawyer association that speaks for their state association, so I can't speak for them. I am in communication with them. I will talk to them. I can explain things to them, but they make their own decisions. Similarly, AAJ works on federal policy, not on state policy. That's to our state associations. So I am a man who speaks from nowhere right now. But hopefully I can be helpful to the committee and to you all in sort of understanding where the trial bar comes down and sort of thinks about this issue and understands it. So from a big picture perspective, I agree with both Harrison and Eric. Commercial litigation financing and consumer litigation financing are two separate issues. I called it apples and oranges. I think of it as commercial real estate versus title loans. They're just different products that are thought of differently. And addressing them both in the 5 minutes that I have is going to be complicated, but I'm going to try to keep them separate as I talk about it. When you talk about this, though, there is one similarity between them, and that access to these products can be either useful or smart. It is useful for the family that cannot put food on their table to have access to some financial product that lets them get to the point that the insurance company finally decides to pay on a valid legal claim, right? They need to float that interim period so they can put food on their table because they can't work. Having access is helpful. Similarly, the small business that's been exploited by a giant corporation whose only shot at maintaining their business is access to commercial litigation financing so that they can maintain their profitable business, it's important for them to have access to it. On the smart side of it, this is kind of like reinsurance. It's probably not a perfect analogy, but it can be a risk mitigation tool, particularly on the commercial side of this, for sophisticated players working on sophisticated issues. With that said, the biggest issue that we have with the model bill, and that you're going to find from trial lawyers across the country, is the automatic disclosure provision that is in the bill. The big problem with this, well, I'll start with this. I appreciate that it's narrow. We have seen automatic disclosure requirements that go so far as trying to get at partnership agreements within law firms and trying to really dig into the finances of every single person who might be involved on the plaintiff side of the issue here. This is a much narrower provision, and I appreciate that. And I specifically appreciate that it already carves out the issue of entities of concern. That is a serious problem, and I completely agree with you. Those sort of entities should have no place in the legal finance system of this country. The one thing I would add, though, is that it should not have any place in it on either side of the V. Currently, this bill is drafted so that it's only entities of concern who are providing litigation finance on the plaintiff side are carved out, which is great. But it should be expanded to cover when that litigation financing is provided to defense firms for after the event insurance, other things like that. There are lots of financial products that are in this area that don't just cover plaintiff side, but also cover people on the defense side. And I think that the committee should take a look at that when they're thinking about this policy. The other thing about the automatic disclosure that a lot of our members have is that most people do not use these products. Especially on the commercial litigation funding side, as Eric mentioned, it is a very narrow group of some cases and some firms that will potentially use these products. The vast majority of the time, this is not an issue at all in the litigation. But by forcing automatic disclosure, you make it a part of every single case. Because whether someone does or does not have litigation financing provides a tactical advantage to the defendant in a particular litigation. Both on the consumer side. So if a consumer, whether a consumer needs to take a loan out so that they have the ability to put food on their table is wholly irrelevant to the case. But if we have to disclose that to the insurance defendant on the other side, they have a duty to represent their client as thoroughly as possible. They can drag out that litigation process knowing that the client will eventually need to take a lowball settlement just to make sure their family has food on the table. On the commercial side, similarly, the issue isn't necessarily that you disclose there is litigation financing, but that you disclose that you don't have litigation financing. Because if the defendant in a high stakes bet the company case does not have litigation financing, the defendant who already has more resources than they do, knows that if they drag this out, they have a much better shot at either forcing this company to fold before the end of litigation, or that they're going to have to take a lowball settlement just to get some money in the door so that they can repay their other investors so that they can dissolve the company later, right? They just won't have the money to pull this out. So that automatic disclosure provision is a problem for discovery abuse. I realize I'm also up at 5 minutes, but I do want to point out two more things, and then I'll turn it over and we can ask some questions. It gives negotiation leverage to the other side as well, to know what position the plaintiff is in. And then the last thing is sort of the PR pressure that's obviously a part of this conversation across the board, right? We're already seeing this issue of litigation finance being used to delegitimize the civil justice system in general, which I think is wildly hypocritical in certain circumstances, that we're talking about a litigation finance measure around litigation when that's what the insurance industry is in the business of to a large extent. And I think that there needs to be sort of a general ratcheting down of the sort of rhetoric and understanding around this tool so that we can have a much more common sense, straightforward discussion about what exactly this industry is and what the pain points and what the issues are in terms of some of these proposals. And I'm happy to do that. There are some good parts of this bill. I'm more than happy to work with the committee on figuring out the best way to draft this policy. So thank you for having me here. And I look forward to your questions.
Robert Gordon?
Well, thank you for the opportunity to join today's discussion. I'm Robert Gordon with the APCIA, representing the majority of the property casualty industry. We greatly appreciate the chair and the committee's consideration of the model legislation to protect our civil justice system from the hidden funders seeking to tip the scales of justice for their profit. And I particularly commend Representative Lehman for advancing solutions to provide more consumer protection and more transparency into these hidden practices. And I want to strongly endorse and agree with Representative Lehman's comments about how much has changed since he earlier identified the need for more sunlight in this area and the potential harm of shadow financing by third-party litigation funders. And one of the things that's changed is the Government Accountability Office, which is a federal agency, not a PR operation. They did an investigation of third-party litigation financing published just last year, and they found it is expensive and may deter plaintiffs from accepting a settlement offer because they want to make up the amount they will have to repay the funder. GAO also cited warnings that sovereign wealth funds may be involved in third-party litigation funding to further foreign policy or military goals. There's been a lot of discussion about sovereign wealth funds pouring billions of dollars into encouraging lawsuits in the United States, and 5 of the largest 10 sovereign wealth funds are in China or Singapore, another 4 from the Middle East. Secret third-party interests are now funding tens of billions of dollars into increasing litigation in the United States. An estimated 30% of intellectual property claims now have hidden third-party dark money involved. And not only are large funders being increasingly shown to control litigation, but again, we're uncovering that foreign actors and a number of our adversaries are essentially weaponizing the third-party litigation funding in our U.S. litigation. Fortunately, the policymaker reforms to create more transparency in third-party litigation funding, they're already starting to help. So just last month, the Wall Street Journal uncovered that an Abu Dhabi conglomerate owned a company called Forest Investment, a litigation financer that owned VLSI Technologies. That's a former chip manufacturer, been defunct for decades, but filed multi-billion-dollar litigation against Intel in Delaware. But when the Delaware judge told VLSI that it would actually have to disclose its litigation funding origins, it actually dismissed its suit rather than reveal its true master. And then only a week later, on March 28th of this year, Bloomberg Law exposed that Putin's billionaires dodged sanctions by financing lawsuits. And Bloomberg revealed that billionaire founders of a Russian conglomerate evaded both U.S. and European sanctions after Russia's invasion of Ukraine through third-party litigation funding around the world, including in New York and London. So we now see state and federal policymakers and courts very much waking up to the dangers of this hidden money. They're actively investigating the third-party manipulation of the justice system. Just this last week in Congress, the Deputy United States Treasury Secretary discussed with the Senate Banking Committee the national security implications of illicit third-party financing and the challenges of foreign adversaries investing in U.S. legal system abuse. And the Deputy Secretary agreed before Congress that there needed to be more transparency of the shadow funding system and supported working together to address the problem, including potentially through litigation. Although this legislation and oversight is being done so far primarily through the states, which is why NCOIL's efforts are so critical. We saw just fairly recently 4 states adopting statutory requirements for disclosure of both consumer and commercial litigation funding. I guess I'm a little surprised others on my panel think legislators can't draft legislation dealing with 2 colors of essentially the same fruit. They suffer same damages and defects, especially when the focus is more sunlight to help detect and limit that abuse. And Indiana and Montana, West Virginia, Wisconsin, they've already done the right thing. And what we're now seeing in these cases is with the third-party litigation funding, a majority of the expenditures are going to the funders and the lawyers, and the funders have no fiduciary duty like the lawyers do to act in the victim's best interest. So a lot has changed since Representative Lehman had the foresight to identify this issue as a problem. It's something very important to deal with. States and the federal government are waking up for the need for more oversight. It's beginning to gain traction, and it's very good timing for the chair to consider model legislation, for the committee to consider its adoption. We strongly support proceeding with the model. We look forward very much to working with you on it to make sure it achieves the intent and very much need that additional transparency. Thank you.
John, last but not least.
Thank you for saying not least. John Schnautz, National Association of Mutual Insurance Companies, happy to be here today. My last comments to a previous committee, in the spirit of mindfulness, started with a moment of gratitude. I will do the same here and thank Harrison for providing this excellent lanyard. It has done a good job of supporting my name tag throughout the conference. Somewhat to my surprise, it was not sabotaged in advance, so spirit of cooperation there. I guess I would reiterate, I think, what Representative Lehman said better than I'm about to at the beginning, which is the model that's before you are several fairly small pieces of a much bigger issue. And the bigger issue is, like it or not, the litigation is becoming an investment market in a lot of different ways. And we don't know all the repercussions of that. It is still a fairly early thing, but I think probably one of the things that everybody up here would probably agree to is it's not going away and it has grown over the years. So I would start with that and then just point out this is looking at some fairly narrow pieces of that much broader issue. So a couple of aspects of the model that I think are very positive that we'll speak to. One, and this seemed to be a point of agreement, is that the model clearly prohibits control of litigation by the funder. I think that's a really important thing, a good piece of the Indiana bill. We think the model needs to reflect that throughout, and we'll have some suggestions on how to make that even more clear. I will speak to, since it was raised, the model does include a limitation on the consumer side on the amount that can be charged. Because it's not obvious in the model, I will just tell you the rate that is being referred to there is a 36% interest rate. So in terms of what the committee might want to do there, I would just advise that's what's on the table. So you may want to consider whether you think that's a reasonable limit or not. But I think that is an important issue to at least have be part of this conversation. There may be better ways to structure it, but to bring your attention to what specifically is included there. On the disclosure point, I think the model needs to be viewed carefully in light of what the Indiana situation was on the ground. Representative Lehman and I have had several conversations about this. Many states have different provisions on disclosure and discovery. In our view, the way that the bill ended up treating these agreements is very similar to how insurance policies are treated in the discovery process. If that is the end result, it is a result that we think is well justified. The analogy is not perfect, but in terms of what ought to be disclosed, we think it is a very strong one across both sides of the V as to what the disclosure ought to be. And we look forward to thinking about other ways that that might be made more clear. Maybe it's the West Virginia approach, maybe it's something a little more modular, but we want to be a part of that conversation. Couple of other responses to other points that have been made, and then I'll stop. First one is on the issue that there ought to be two models. I guess I would just point out this is already a fairly bifurcated model. It's got one set of rules for consumer, it's got one set of rules for commercial. They don't overlap a great deal. The one thing that's in for both and that we think is the most important part of the model is disclosure. That's the commonality. Otherwise, I guess they could be on two different sets of paper, but other than that, the model already recognizes some very key distinctions, so that's already done to some extent. Finally, one of the previous speakers talked about kind of this leverage argument on disclosure, and if I understood him right, he was arguing that in certain circumstances, the opposite things are true. The argument that I've heard most often on disclosure is, well, if the plaintiff has to disclose it, they're going to disclose that they're in financial dire straits. That's kind of a strange argument to me because it's sort of like saying, well, I would have been in financial dire straits, but guess what? I got this funding and now I'm not. So I don't really understand how that disadvantages the plaintiff from a leverage standpoint. It would seem, if anything, the opposite. On the other hand, the fact that the plaintiff doesn't have funding, I think, tells you almost nothing about why they don't have funding. Maybe they don't have funding because they don't need funding. There's no real inference you can draw there that the plaintiff is in financially some sort of destitute state just because they don't have funding as part of the case. So those are all the points I'll make for now. We look forward to continuing to be part of this process. Hope to answer any questions you have. Thank you.
Well, thank you to our panelists. I'll now open up the conversation to legislators. Does anyone have any questions or comments? Please go ahead.
Thank you, Madam Chair, and thank you to the panel for your discussion. I'm glad you brought this situation to light because it's very similar to payday lending, I think. Okay, it just really resonates that. And that 36% interest, who can afford that? You know, so I'd like to know, what's the difference between what you're proposing and payday lending?
Thank you, if I may address that. There's a big difference. Payday lending creates debt, creates a cycle of debt for a consumer. And consumer legal funding does not create debt. The IRS has even weighed in on this and says if a transaction with consumer legal funding is done as a loan and the company gets back in less than contracted amount, meaning the case settled short, there's not enough money to pay, then that funding company has to 1099 that individual because it is a forgiveness of debt. But if it's done as a funding, like we have in the states where we pass it, like Indiana and Missouri and several others, that is not debt. So we do not put consumers in a situation of debt. It's also the only financial product out there that you only have to meet your obligation if a third party gives you money. If that third party does not give you money, meaning you win a settlement, then you're not contractually obligated to make it. Whereas in payday, car title loans, home mortgage, credit cards, the person that provided you those funds, they don't care where you got your money from. They just want your money. We want to make sure you get it from your settlement, and then secondarily, that there's enough money to pay us back, meaning the way we have it drafted in states is attorneys, medical liens, statutory liens, they all get paid first. Then we get paid. So it may sound the same, but it's a whole lot of difference between the two. Finally, this is the only transaction that I'm totally aware of that in anywhere that it's offered, your attorney has to sign off on it. If the consumer's attorney looks over that contract and says, this is not in good interest of my client, it doesn't happen. In fact, we put that in statute, that if the attorney doesn't sign off on that, it doesn't happen. In most states, you can go out and get a $500,000 mortgage, and you don't have to have an attorney there at closing. But just to get $500 from any one of our companies, the consumer's attorney has to look over the transaction and say this is okay for them to do. So I think that's maybe a long answer, but I hope it answers your question.
Oh, I appreciate your answer. Thank you.
All right, we have Delegate Westfall, then Representative Kiker, Senator Gossage, and then we're going to go to Representative Lehman. So Delegate Westfall.
Thank you, Madam Chair. This is for Harrison. So when and why do people seek your type of funding you were talking about?
Yeah, sort of just to reiterate a bit of what Dan said, it's just a way while they're pursuing justice after they've already filed their claim. So this is not initiating any litigation in any form. But let's say, for example, someone gets in a car accident through no fault of their own, and while they're waiting their settlement from their claim, they have no way to fix their car, they have no way to get to work. And so this allows someone to come in and fill that gap for them, or put food on their table, or any other life need that they would want to spend it on.
Thank you. Thank you, ma'am.
Rep. Kiker.
Thank you, Madam Chair. So I wanted to go back to the story that we started out with that just caught my ear. Does the financing company have access to the discovery documents through the course of the trial or the discovery process?
No, we don't. And in fact, we're very clear that we do not request privileged information.
What about the other side where we're financing on the business end of the Intel example, if you will?
I'm not aware of that being a condition or a part of any of this. I'm not opposed to that provision being included in this bill or being a model policy. So I don't have, I would think that that's protected already. Yeah.
I hope so. I just think about the nature of some of the more expensive ones that are going to be out there, the more detail that needs to be there, and I think that should be a consideration. And out of idle curiosity, what's the most common setup for interest or a range of interest that is assessed on these fees that are lent?
I mean, it's a lot of it's risk assessed in states like Indiana. We have rate restrictions in place. Some states don't. I can tell you that two examples I point to are Oklahoma and Utah. There are no rate restrictions in either one. I can tell you for a fact those two states have probably the lowest rates in the country because the market is dictating the rate. And in both those states, 3 companies have started up that were not there before the statute went into place, and they're all local companies. And they are giving the national players a run for their money because they're right there in Oklahoma City, they're right there in Tulsa, they're right there in Salt Lake. And they're going to the attorneys who they deal with on a regular basis and saying, hey, if you've got a problem, I'm right down the street here from you. You don't need to deal with that guy in New York or the guy in LA or the guy in Chicago.
So let me ask it this way. What is the lowest to highest range during your career that you've heard assessed on these dollars on an annual basis?
I'd say probably in the 30s to the mid 40s range area. And I think a lot of times they're also risk assessed, meaning that the case is more riskier, just like in insurance, property casualty insurance. If a driver has a very poor driving record, they're going to pay more for it.
And I'm not trying to mitigate the risk, but I want to understand that the average typical rate is between 30 to 40% per annum on the money's lent.
Typically.
Thank you.
Senator Gossage.
This came up in our legislature last year. It was brought by the Kansas Chamber. And what's interesting to me is I had to have them come into my office several times. I'm like, what am I missing? I don't quite get this. So what I was trying to understand is, because what we heard was, we just want to level the playing field. And I'm like, but if somebody is suing someone, you typically assume the person doing the suing is the one that was harmed, and they're trying to say maybe they don't have the money to come against this person, and so they've got somebody who's invested in them. And what the chamber had shared with me is that is not, we're not trying to stop that. We're just trying to say disclosure. They should just be able to disclose that they have that. Could someone address the difference?
Yeah, sorry. I can try to address what you're talking about. So I assume you're talking about on the consumer side, not on the commercial side. Or are you talking about on the commercial side?
Typically, but they tell me it's commercial.
It's commercial side, okay. So the issue on the commercial side here, I guess I'm not quite sure where they're coming from in terms of the issue too, in one regard. And so maybe we'll talk about that. But I do want to talk about the remedy that they've proposed here, which is disclosure, right? And so even if you assume that there's something problematic, maybe I guess with where the money's coming from, which despite the fact that it's completely carved out of this bill, seemed to still be the basis of their testimony here today, that somehow the disclosure needs to come from the lawyer to the opposing side in this side, right? Like, I can tell you from my conversation with our members, they are working with a firm, a reputable US-based, commercially regulated firm that's providing sort of litigation funding in the handful of cases where this sort of thing is available. They don't know where that firm got their money. And so the idea that the lawyer is going to be the one who's going to know to disclose it to the other side is, I don't know how we get to that. They're not the ones there. But even if you assume that there's something problematic with this and that the lawyer might know about it, what does disclosure do other than provide the sort of tactical advantage that are already laid out here? I mean, I think if there's a problem with the funding, then you can ban the funding, right? And that's what this bill does for the sort of funding that we've identified for foreign entities of concern, right? If you have a problem with litigation funding in the commercial space, regulate the problem you have with funding in the commercial litigation space. The disclosure doesn't really do anything from that perspective. But even if you assumed that disclosure somehow did do something in these cases, and the disclosure was an appropriate remedy in some way or the other, why is the disclosure not to the Attorney General or to the Secretary of State or some sort of entity within the state that could somehow do something with that information to regulate whatever the problem it is with that? Maybe the Bar Association, somebody who could do something with that would be a much more appropriate sort of target for that disclosure. But even if you assume that somehow there's a problem with third-party litigation disclosure in the commercial space, that the lawyer is the one who should know about it and should be the one that's disclosing, and that the litigation funding should be disclosed in the context of a particular piece of litigation, why is the Insurance Defense Counsel the appropriate party to be disclosing that to? Why not to the judge who could do something about it in camera if there's a problem, which I've yet to see I sort of identified here. And so I think that that's kind of the chain that you're probably maybe sort of correctly intuiting doesn't really make any sense as to why it is that the Insurance Defense Counsel is the particular party that needs to know about this.
If I may, it's just that, so what I've been told is that on one side, the one who's being sued has to disclose how much insurance they have. And so they're saying that this kind of equalizes that by you have to disclose how much money somebody has invested in your case.
I apologize for misunderstanding. The reason why is because it's relevant and proportionate to the issues that are before the court. So it goes through the standard rules of discovery generally. And the reason why you'd want to know why, if they have insurance or not, is you want to know if they have the ability to satisfy a judgment against them, right? There is no corresponding need to know if the plaintiff has the capacity to bring the litigation. That's just sort of implied by the fact that they sued.
One last question, Representative Ollerson.
Yeah, I appreciate it, Madam Chair. This is all new to me, and I'm learning a lot here as well. So I guess my question is more simple, and that is, I've heard this number 36% finance charge thing thrown out. I'm sure that's not the case in all cases, but that does sound like a large number to me. Assuming there are also lawyers that are representing these clients that don't have the money, are they getting their legal fees paid on top of that? And if so, what do the claimants, if there is a judgment in their favor, what are they left with in these circumstances where, you know, an attorney may claim 20 to 40%, right? And then there's a 36% finance charge. So what, in the case of some sort of a claim, what's left for the plaintiff?
We typically fund no more than about 10% of what we think the value of the claim is. So to make sure that there is money left over for the consumer on it. You have to remember, at the end of the day, the consumer is not going to settle the case unless they're comfortable with the money that they're going to get in the end of it. The 30, you know, the number that's been batted around, you know, 36% number, everybody thinks, oh my God, that's high. Just because a company charges a rate doesn't mean they make that rate. You have to remember too, there's a lot of costs associated with this. Right now, the cost of capital for some of the companies, especially the smaller companies, is 15 to 20%.
So secondary question, if I may, related to what you just said. So obviously, most of the attorney's fees in these situations are probably contingency-based.
Correct.
What about the financing company? Do they, if their judgment doesn't go their way, do they lose
we
all
get
their
absolutely
principal?
nothing. Even in the case, and it does happen on occasion, where the consumer drops the claim. So let's say they're living in northern Minnesota and said, you know, I'm done with the cold weather in International Falls, I'm moving to Miami, and they drop the case. We can't do anything about it. The only time we can go after a consumer is if there's fraud involved. And in order for fraud to be involved, because we have the attorney sign off on it, their attorney would have to be involved in it.
Okay, so
and I
there's-
don't know many attorneys that win to lose a law license for $3,000 that somebody else got.
So it is fair to say then there's parity in that both the attorneys as well as the financiers are, it's high risk, high reward, essentially.
Correct. And I just give you some quick numbers. About 30 to 40% of the time when we polled our members last year, 30 to 40% of the time they get less than contracted amount, and about 10% of the time they get absolutely zero. And that could be a myriad of things of they lost the case, they dropped the claim, whatever it is. Or there wasn't enough money left over, even if there is a verdict. So let's say we projected the case to settle $50,000, but in reality, it settled for 10. After everybody's paid, there's nothing there. And I've actually seen transactions where the consumer, because they got legal funding, in the end, got more money than anybody else. I mean, that does happen.
All right, thank you, everyone. Representative Lehman, would you like to make some final comments?
Yes, thank you, and thank you, everybody, for your comments. I took copious notes, I wrote down several things, and I think I've narrowed this down to, I think, the two issues that are taking away that probably need to be tweaked or at least looked at is, I'm hearing separated the two issues and disclosure. And so with that, I look forward to working with everybody moving forward and get this to a place where hopefully we can have something to vote on this summer.
All right, thank you, Representative, and I look forward to discussing this throughout the year. And if anyone has any comments or questions or would like to reach out to myself, Representative Lehman, or the NCOIL staff. Next on our agenda is a discussion on the development of NCOIL Earned Wage Access Model Act. As a reminder, we had a discussion on this topic at our last meeting in November, and you may have heard of this in your state, where these types of providers grant worker access to wages that have already been earned before their scheduled payday. A few states have taken action and enacted laws with licensing and other provisions. After the discussion in November, NCOIL Vice President, New York Assemblywoman Pam Hunter had stepped forward expressing an intent to develop a model law on this issue. Unfortunately, Assemblywoman Hunter couldn't be here today as there were some last-minute schedule changes relating to New York's budget adoption. But she did convey that before introducing a first draft of a model, she wanted to get some feedback on whether it should follow the direction of Nevada, which was the first state to enact a law on this issue, or follow other states such as a bill that has been introduced in her home state of New York. You can view the Nevada law and New York bill on the website and app, and some material comparing and contrasting the laws has also been distributed before you. We have several speakers here today, so please be sure to limit remarks to no more than 5 minutes so we have enough time for question and answer. Let's start by hearing from Matt Smith from the Connecticut Department of Banking. We'll hold questions until everyone is finished. Matt, please go ahead and get us started off.
Thank you for having me here today. It's a pleasure to be here to discuss this very important topic. I'd like to start off a little bit talking about Connecticut's small loan and related activities law. Under this law, it allows lenders to lend up to $50,000 beyond the 12% usury rate in Connecticut. The interest rate cap for this is 36%. Last year, under this act, a license is required for people, for companies that are lending beyond the 12% for a variety of activities, which you can see up there. But particularly for our discussion, it does define as licensable activity advances of money on a borrower's future income or advance of pay. And I think that that's important here today. Going on to the next thing. So again, under this law, your APR cannot exceed 36%. And we can move on to the next one. So last year, the legislature, the Connecticut legislature, at the request of the department, made some modifications that included in the finance charge and in the calculation of the APR, tips and other voluntary and expedited fees should be included as part of the cost of money. This was a proposal the department had placed publicly back in January of last year. There were public hearings on it by the legislature, duly noticed, as well as the opportunity for public testimony on this bill. The legislature passed the bill, and then on September 11th of 2023, the department issued industry guidance that captured not only earned wage advances, but litigation settlement and some peer-to-peer lending companies as well, both of whom had reached out to the department during the last legislative session to talk about the department's proposal. Sorry, I'm going here. Important to note that one of the reasons that this industry, that earned wage access, earned wage advances should be subject to oversight and licensure is we've already seen some bad actors in this space, particularly a class action lawsuit that resulted in a $3 million return of monies to consumers who are harmed and a $9.5 million in forgiveness. That was Earnin. And then Bridget, another earned wage access direct-to-consumer model, was fined $18 million by the Federal Trade Commission because of unfair and deceptive practices. So with that, earned wage advances are indeed loans as captured under the Connecticut Small Loan and Related Activities Act. Now, I know that there are a lot of insurance people here, but if you were to ask any banker, what is it when you give somebody money and you expect payment in return for a fee? They would call it a loan. And that's exactly what these are, small loans. It's another iteration of a payday loan that we've seen consistently over the years, designed to prey upon vulnerable consumers to circumvent lending laws. We've seen this with storefront payday lendings in Connecticut, tribal lending. This is just a high-tech, innovative way because you can use your smartphone to make it easier for you to have access to cash at an interest rate, at an APR that exceeds 300%. When considering the model law, I think it's important that it requires unfettered access to company records for the regulator. It requires thorough examinations, the vetting of ownership and control people in the organization, the need to have a surety bond, as well as, very important, a disclosure to the consumer on the actual cost of the money in the form of an APR calculation. It is something consumers are familiar with. It's how you buy your car. It's how you find a rate for your mortgage. While they may not understand exactly what an APR is, they generally know that the lower the APR is, the better it is for them. And then finally, there should be no exemption for any money transmission exemptions in any model law. Money transmission is a very different space than the small loan lending. One can imagine that as this business model evolves, you're going to see you can possibly, and this is only me conjecturing, the possible movement of money between the consumer and another friend of theirs, or paying a bill or something like that. And I think that it's important that as non-bank services begin to move into the spaces of traditional banks, which do not have the proper supervision, that we can expect, or essentially deregulating the financial services space. And in that, when you're deregulating, non-banks, when banks have such strong regulation on safety and soundness, that more services moved over to the deregulated space, small ripples in that space can have larger consequences for the entire financial system as a whole. So I think that's important as we look at this, to think about what kind of regulation we want. We want regulations that protect consumers and also balance that with a healthy financial services system. I think that's everything. I'm not sure if I caught all of my points, but happy to answer any questions.
Okay, next up, we're going to hear from Ben.
Thanks, Chair. Thanks, everybody. I'm going to start with a little bit of a recap from what we talked about a couple months ago, just high level what earned wage access is. When you earn money, you have legal right to that money. If you're working and living paycheck to paycheck, you might only have $50 in your bank account, but have hundreds or even thousands of dollars that's legally yours, and you should have access to it. So we provide that service with no mandatory fees and no recourse if somebody doesn't get paid back. So Earnin, we have about 2 million customers and we estimate there's about 5 million customers across the country that use this service. So every elected official has earned wage access customers in their district. Who uses this service? Amazon and Walmart employees are generally always our top 2 employers, but some other surprising top employers, postal workers are always in the top 10. Hospitals and school districts are also often in the top 10. So, folks where it's very human capital intense and a lot of people are making an hourly wage. We do this, we don't sell any data. The only way that we make money is by voluntary fees or tips. We say, hey, if you like this service, give us some money. If you need this money immediately, you can pay a fee for that. But nobody ever has to pay anything. Many of our customers never pay anything, and it's only if you choose to pay it. There's no late fees, there's no interest, et cetera. Let's see. So as we're talking about the model policy here, the first state bills came about 4 or 5 years ago. They were not really very well thought out. We've done a lot of work in the interim. Last year, the Council of State Governments adopted the Nevada bill as their model bill, which was the first EWA bill that passed. 3 other states have passed that bill. Missouri, Wisconsin have both been signed into law. Kansas is sitting on the governor's desk. I think Monday it will either need to be signed or become law in Kansas too, so that'll be the 4th state. California did a law by rule. It's sort of interesting. They considered it a loan but exempted it from the lending statute and said you don't need to become a lender. You can get registered under this other statute. So I think there's maybe 15 or so other states that have considered this legislation one way or another. So I want to talk, I'm going to talk a little bit, I'm going to do a little pre-buttal to the CRL presentation, and then I'm going to respond to Matt a little bit as well. CRL, I got asked this question on here after our last NCOIL meeting, like, why do they care about this so much? And like, are they involved in the financial services industry some way? They generally don't disclose this, but CRL is a subsidiary of a multi-billion-dollar credit union that essentially has almost no capacity to compete with digital-first financial services. You can see, if anybody's on their phones, you can look their app up in the App Store, and you can see some of their ratings. 3.3 stars compared to 4.7 stars. So they have a model where they claim to be an impartial actor, but then they essentially just attack anything that is new and innovative, it's frustrating. So my apologies, that is a little bit negative, but I want to talk a little bit about some of the data that they have put out recently, which I'm sure they're going to talk about. So they put out this report that basically claims that if you use EWA, you get more overdrafts, but correlation is not causation. It'd be like saying we followed nursing home patients for 6 months, and we found that anybody that went to a hospital had more stitches afterwards, therefore hospitals are very dangerous. There's just a ton of reasons why the data that they disclose about this industry is misleading at best. So we'll see. If anybody wants some, answer some questions after the presentation, I'd be happy to talk about them. One question that's going to come up a bit in all the presentations you already heard from Matt is the question of APRs and fees, et cetera. Basically, the Connecticut Department of Banking changed the way that APRs are calculated. It is not the way that APRs are calculated under federal law that everybody has been abiding by for 70 years. There's also a number of other fees that most financial services companies can use. You can see here just like our fees compared to some of the fees that the self-help credit union uses. So $45 if you lose your PIN for your ATM and you need it soon. That's a lot. So anyways, comparing EWA to credit cards, the average earning customer spends about $60 a year using Earnin. The average credit card user spends $1,000 on late fees and interest. That's from the CFPB. And just to give you an example of sort of what happens if you don't pay Earnin back, if you get $100 from Earnin, you don't pay us back, you never owe us more than that $100. If you take $100 on a credit card, I use specifically the Self-Help Credit Union credit card, a year from now, you're gonna owe $182. So even though the APR for that is only 16%, but once you compound that monthly and you add in the late fees, that really adds up quickly. So the fees are quite high and APR is pretty misleading. So that's the next thing I want to talk about, APR. The Truth in Lending Act is about a 70-year-old law, federal law. That's how APR is calculated. So there's a number of transactions that technically have 0% APRs the way the law is calculated. But essentially what the DOB did and what CRL has done to attack this industry is said, well, we wanted to redefine APR differently to essentially scare people about this product. And so, you know, using their claim, we have about a 200% APR with our $3.99 fee, but the late fee for their credit card, higher than that, 300%. An ATM fee would be 700%, and an overdraft, 1,800%. So all of those things, 0% APR, but if you recalculate it differently, high numbers that you could scare people with, but you know, even at that, ours is still lowest. So what happened in Connecticut? The first quote up here is from Matt's testimony on this bill. The change in the bill from his testimony was about income share agreements. Earned wage access never came up in any of the testimony, in any of the discussions. It doesn't appear in the bill. It doesn't appear in any of the in any of the materials. We've asked dozens of legislators, hey, like, how'd this happen? Have you ever heard of earned wage access? 0 people had ever heard of earned wage access before they voted on it that we've talked to. We like had a conversation with them, hey, how'd this happen? When we first talked to them, oh, this was a misunderstanding. We didn't really, this wasn't our intention. And then as the circumstance went on, or as the time went on, oh yeah, no, this has always been this way. So we FOIA'd their emails and we asked, hey, tell us about all of the EWA conversations you've had with legislators. None. They never talked to legislator about them. So as legislators, I think you guys should be very wary of regulators that come to you and say a bill does one thing and then it does something very different. And in this particular instance, it was very harmful to our customers. And I mean, I heard stories from our customers about what this did. We had to pull out of the state on basically 2 weeks' notice because of their guidance, and people were just devastated. We followed folks.
I'd like to respond to that at some point.
Okay, just hang on, Ben, one more minute.
So we followed folks in Connecticut and compared them to folks in New York, and we found the folks in Connecticut had 10% more overdrafts compared to similar people in New York, thousands of dollars in overdrafts that they shouldn't have had to get. They're very stressed out. You know, like I understand you guys have this, this presentation. So just like a lot of financial stress and wellness that happened to these people because a financial service that they had been relying on for years was taken away from them because of the change to this law. So I'm gonna pause there, thanks.
Elise?
Thank you. My name is Elise Hicks. I am the Government Relations Manager for Daily Pay.
Elise, please pull your mic closer.
I'm sorry. Are you guys able to hear me? Okay. I am the Government Relations Manager for Daily Pay, and I am just going to highlight some things that I think you guys went over last meeting and tell you a little bit more about Daily Pay. My clicker, okay, great. As Ben has already gone over what earned wage access is, Daily Pay, our model is employer integrated, which means we actually contract with the Targets of the world or the employer to integrate into their time and attendance and payroll systems. Time and attendance for our hourly workers and payroll for salary workers. And that data updates 4 times a day, so we get fairly close to the net amount that people are able to access and transfer to their accounts. So this is one of my favorite slides. Companies run payroll about once or twice a month. My husband was a teacher and he got paid once a month, so you can just kind of think about how much he had to budget. He was also in the military and he got paid semi-monthly, so twice a month. And at that point, we were living in California on his income. So 11% of companies run payroll monthly, 36% of companies run payroll biweekly, 32% of companies run payroll weekly, 0% of companies run it daily. Want to take a look at some strategies that our customers use before daily pay. 57% paid a bill late. 49 borrowed money from family and friends. 39% overdrew their bank accounts. 21% took out payday loans, and 21% made a loan payment late. Daily Pay likes to say that we are overdraft fee eliminator. So 38% of people that were surveyed overdrew their accounts before Daily Pay, and 97% rarely or never overdrew their accounts after Daily Pay, and 75% of those people attributed that that savings to Daily Pay's use. We also like to say we're a payday loan killer, so 28% of people that were surveyed took out a payday loan at least once a month. After Daily Pay's access, 95% stopped using payday loans, and then 88% of those people attributed that to Daily Pay's, the use of Daily Pay. Here we can see that 39% missed a loan payment or they paid the bill late. After Daily Pay, 88% had less trouble paying their bills late. Daily Pay has partnered with 970 employers. We have 1.6 million enrolled users, a 36% adoption rate, which means everybody that has access, or the employees that are employed by the employers that we contract with, have access, but they don't adopt it. So 36% of people that have access adopt or start using Daily Pay. The average transfer amount is $108, and 49% of platform users make no transfer, but they kind of use it to see what they're earning, what their net earnings are. This is also important. 66% of all platform users each month then take a 3-month to 1-year break after using our platform for the first time. There's probably some trepidation about overuse or high frequency. This is what we're seeing when we are surveying our customers. Another great slide. This is our fee structure. So there's no employer fee. If someone wants to use Daily Pay and their employer has given them access to use Daily Pay, we have 2 free options. One is a standard ACH delivery, so they can wait about a day to 3 days, usually a day, to get that if they want to transfer it to their bank. We have an instant transfer fee to our Friday card, which is our prepaid debit card, if they would like to use that. If they would like to get that money instantly to their bank account, there is a $2.99 to $3.49 instant transfer fee. We all know that we do not live in a real-time payment system, so it does take money to move money, and that is a flat fee. So depending on when the employer signed up with us, their fee is either $2.99 or $3.49. We also have a financial wellness platform, and people do use us as a financial wellness tool. One thing that I like to point out is 93% of Daily Pay users check the app for their earnings, like I said, to make spending decisions. 83% of Daily Pay users say Daily Pay helps them make better choices because they know how much money they're earning from day to day. We're also good for businesses. We lessen the turnover rate by 45%. My neighbor, which is also my brother and sister-in-law, she noted that I work for Daily Pay, and she told me that she actually took her job because Daily Pay was offered at this job. People like having access to their earned wages when they need them most. So that goes to my next point, 52% and faster recruiting for businesses, 3 times more engagement for businesses, and it lowers absenteeism for workers.
30 seconds left there, Mike.
Okay. I want to hone in on the 3 states that have already signed and passed laws: Nevada, Missouri, and Wisconsin. In over 10 states, bills were introduced in this legislative session. 6 states passed at least 1 house. 2 states passed both houses. And with the laws that are already on the books and those that were presented, we do as an industry advocate for strong consumer protections, and these are the list of consumer protections. Hopefully my slides are available for you guys to take a look at these consumer protections, and I don't have to go through all of them, and I'll just stop there.
Monica?
Yeah.
Are your slides in the right
Yeah.
direction? Okay. Well, while we are waiting for those slides to load, I want to introduce myself. My name is Monica Bergs. I'm Policy Counsel with the Center for Responsible Lending. The Center for Responsible Lending is a nonpartisan, nonprofit policy advocacy organization. It was started in North Carolina in Durham, where I live now, and its initial mission was to shut down payday lending in the state of North Carolina because we came to recognize a pattern of a debt cycle, patterns of harm, and patterns of usage that prevented people who access payday loans to build true wealth and stability for themselves. And I found it interesting that one of our speakers today mentioned how folks had been reliant on their products for years. And when it was taken away, there was this fallout. And that is the exact type of harm that we recognize in payday lending and similarly in Earned Wage Act and Earned Wage Advanced products that our research is affirming. And so I just want to talk about that a little bit. And so the report that was mentioned was an analysis of over 14 million transactions from consumers. From that report, nearly 2,000 customers completed over 37,000 Earned Wage Advanced products, and we took a snapshot of an 18-month period of them using this product. 75% of the users took out an additional advance the next day or the same day that they repaid the other one. So that cycle of reborrowing that is signature to payday loans continues with the use of this product. And I find it interesting because we heard that when folks switched over to Daily Pay, they stopped using payday loans because it was replacing the same exact purpose they were using the payday loans for. We also saw from this study that 48% of users use multiple EWA apps in one pay period. And that's probably because, as you see on the next slide, most of the payday apps, most of the Earned Wage Advanced apps limit the amount that you can take out to $100. I'm a single mother with 2 children. When I go to the grocery store, I'm praying that it comes in at $100 these days. It's such a small amount of money that folks are stacking the apps against their same paycheck that they're hoping to try to make ends meet between those periods. Those small, frequent transactions result in high fees for users. Just like payday loans, you can see on the screen here, the APRs are astronomical. What that means is, if I didn't have $80 to get groceries and gas before my payday, when I have to repay that loan on payday, I need to take it back because I still don't have the money. I took it away from money that I was anticipating, and as soon as I get that money, I have to pay it back. So what's happening with the companies is they're giving you that same $80 and repeating the fees that you pay on that same amount of money. And that is why it's so profitable. That is why some of these industries are looking toward going public, because they're bringing such a healthy amount of return on the funds that they're lending. And to note, this term access is misleading because they're not facilitating access to wages from their employer to the employee. They're third-party companies giving their own money from their own capital to facilitate these transactions. And that's an important distinction because you can't do that for free. And so they don't want to hear us talk about APR because APR illuminates the finance charge to access this money. It's telling the consumer how much it costs compared to other options to handle the financial issue that they're facing. But when you conceal that, when you diffuse it for tips and fees and subscription, it makes it harder to compare. It makes it almost impossible to know exactly how your money is being drained. And so, as you can see from the research, and I encourage you all to take a deeper look at the full report, these markers of payday lending are the exact reason why we think there are some essential protections that need to be included in any model law. And, clearly from the research, it's clear that these products are more harmful than helpful to consumers. But even if you as a policymaker sincerely want to make sure this product is available to consumers in your state, guardrails are essential. I mean, even if you have a vehicle, cars are useful, but we still mandate seatbelts, right? So regardless of how amazing and life-changing some folks believe these products are, as regulators and as policymakers, there's a powerful opportunity to make sure consumers who do see a need in these products have appropriate protections. Those minimum protections, and I'm sorry, I don't have my glasses, and I need to acknowledge that I need them at this age. The minimum protections include, and I think one thing that's really wonderful about the New York bill is the tips that these lenders can solicit are a part of the total cost. And it does contemplate a cap on those total costs. That's great. However, it doesn't state what that cap is, and it leaves it to the regulator to decide. And then paired up with that provision, it says that if you are offering earned wage access under this bill, then you're not subject to the state usury cap. And what that does is it kind of allows the regulator, oh my gosh, thank you. Oh, okay. Well, I think my vision is a little bit stronger than that. But maybe in a few years I'll need these. But what that does is, I'm sorry, I lost my train of thought. Right, when we say in the bill that the regulator can decide the cap on fees, but we also say that these products are exempted from the state usury cap, it compels the regulator to allow fees that would exceed the state cap. And in a state like New York, like Connecticut, like Vermont, where they have already put in comfortable, reasonable limits on APR, we don't want to allow these payday-like products to get a carve-out from those strong protections. And with that, I'll pause, and hopefully you all have more questions. Thank you.
Okay, thank you, everyone. I'll now open up the conversation to legislators. Do we have any questions? Representative Hefner.
Thank you. Thank you, Madam Chair. Thank you for your presentations. I recall hearing this. I can't remember which end coil it was. And my first initial was, of course, the thing that we do is we forget about the education on financial literacy first. And I don't ever hear people, a lot of kids, young people that didn't have it in high school as I did. I'm like 55,000 years old. So I did have that in high school, but I know that I had to teach it to my kids because they don't teach it. And even if, I think it's a good idea that we could get the money that we earned earlier, but they don't even know really what that is all about and what the next steps are. It's challenging enough. I remember when I was young, my mom was like, you got to have a good credit so you can buy a house. Well, I bought a house when I was 20. I had great credit, but it's not possible for young kids to buy houses these days. So that's not even one of those scare tactics, to have good credit. So I'm just wondering, in each of your presentations, I didn't hear a lot about that, where we should start that earlier. I know education in my state is something that we're really talking about, and requirements, and I don't want to add anything, but this is important. And you all can talk about, you said this and I said this. The only thing that I know is that we're talking to a big culture of people who have no understanding about what those missteps are with saving. I do like, in a previous presentation, talking about putting money in a place for later. Maybe we start out and look at a different model, whereas when you get a check, we take $5 away and put it into an account, and it grows, and if there's an emergency, we use it. I don't know. But right now, we're not really teaching all the things that your vehicles, the lending, and comparing it to a credit card or a bank draft still is on a huge population that has no idea. So I'd just like to hear where financial literacy comes in all this, and that if that's being something that you push also instead of just talking against these products. Thank you.
If I could just briefly respond to that. I appreciate you raising that issue, and I spent most of my time in law school trying to understand how to increase literacy in the exact frame that you mentioned. And during my time, I was honored to hear Professor Darity, who is at the Duke's Economics Center in North Carolina. He has spent his career and his research focusing on this exact issue. And one of the things that his research actually revealed is that financial literacy, while it is important and powerful, actually has a much smaller impact on the wealth gap that we're witnessing in our country. And the main thing is an ongoing gap between living expenses and reasonable wages. And so even you can understand everything about how to manage your money, but if you're constantly trying to take care of yourself or your family on a salary that just does not cut it, and a lot of times you'll hear folks or certain industry people say, there's no other solution, that's why we have this product. But there are solutions. But in the meantime, it's important to recognize we don't want to overburden people with fees that they can't afford in the absence of real viable solutions for that gap.
For a follow-up?
One thing I'd like to add to that, Robert, is that at the Connecticut Department of Banking, we do have a fairly robust financial literacy program. And we were very supportive of a bill that finally got passed last year that made financial literacy, wellness, and education part of a requirement to graduate high school. So to answer your question, we are making some strides in that regard.
Thank you.
Thank you, everyone. And I think in the interest of time, we're going to close it out there, and thank you to the panel, because Assemblywoman Hunter is going to be bringing the model forth, and we're going to have further discussion with this at our summer meeting. So we'll have a draft model in Costa Mesa. And in the meantime, if you have any questions, comments, or you'd like to add to that, please reach out to myself, Assemblywoman Hunter, or the NCOIL staff. And with that, I have one last piece of business to raise. Our Workers' Compensation Insurance Committee has jurisdiction over a model law dealing with structured settlements. It was brought to our attention that some folks who have an interest in structured settlements weren't aware that the model was in the committee, as it does also have an annuity aspect to it as well. So starting now and going forward, this committee will provide notice to everyone when that model is being discussed by the Work Comp Committee. For those who may have missed the Workers' Comp Committee yesterday morning, there was a presentation on structured settlements for those that may not be familiar with this product and laws surrounding them. It hasn't been decided yet as to whether the model or structured settlements in general will be put back on the Work Comp Committee's agenda for the next meeting. If you have questions regarding or comments, reach out to the chair, Michigan Senator Lana Thies, or the NCOIL staff. And with that, Representative Ferguson has a couple comments to make.
I just wanted to remind all the women that we're going to have a little meet and greet of women legislators in Melody B, which is right outside the room. So if you'd like to get together and chat, we're welcome, all of you, to come.
Okay, with that, I would ask for a motion to adjourn. Second? Second. All those in favor? Thank you.